Thank you very much for being here with us on the short notice. We know that we had our status hearing in the case yesterday in person in McCulloch County. I had requested that Ms. Davis appear in court. She did not do so. We're here today accommodating her attendance by Zoom. Thank you all for circling back around here today. We'll go ahead and have announcements for who all is here. Let me just begin with you, Ms. Surratt.
Chelsea Surratt, attorney for the department.
All right, and Ms. Moore.
Terry Moore for the department.
All right, Ms. Palmer, you're next on my screen.
Amy Palmer, I'm the CPS caseworker.
Okay, thank you, Mr. Wicker.
Joseph Wicker, I'm the Child Protective Investigations Program Administrator.
Where are you located, Mr. Wicker?
In Odessa, Texas.
Okay. And so the RD for investigations, your supervisor is who?
It's Lorena Maldonado.
And where is Ms. Maldonado stationed?
In El Paso.
Okay. And so Ms. Davis is here. She works directly for you. Is that correct? You're her direct supervisor?
That's correct.
All right, Ms. Davis.
Yes, Carla Davis. I am the Child Protective Services Investigation Program Director.
All right, thank you. We have the clerk here from McCulloch County and our court reporter, and then Ms. Gaiman is here. I think she indicated she's driving from the CASA program. And Ms. Corbin, you're in the top corner. I skipped you. I apologize. Go ahead.
Sure. Valera Corbin, I am the attorney ad litem for Evelyn.
All right, thank you. Thanks again, everyone, for being here. Let me just go ahead and swear everyone in that is not an attorney. I guess that's just the three of you. And Ms. Gaiman, if we need your input, we'll swear you in as necessary. Do each of you solemnly swear or affirm that the testimony that you give before this court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Okay, as you see, Zoom now recognizes when you raise your hand, so it always looks like I'm asking a question when I'm swearing people in. All right, so let me cut kind of through the chase here. I hope everyone has had a chance to review the affidavit that was attached to the initial removal. Mr. Wicker, have you reviewed that document?
Yes, sir, I did.
All right. I think, we can kind of skip to the second page there. There was a lot of activity going on February 23rd. I think I'll just read that paragraph, which is the third paragraph there on that second page. On February 24th, Elvin, the father, called law enforcement on 2 occasions due to the child becoming physically aggressive, trying to harm him. Brady PD responded, removed the child, and took her to the office. Father attempted to file assault charges. An emergency detention order was denied, and the father refused to take the child back into care. Of course, we know now we have an 11-year-old child. I think we had a report yesterday as to her disabilities and assessments. And then on February 24th, I, being Mr. Barnett, the investigator, spoke with the father on the phone and explained to him the department's stance and plan moving forward. This is Colton. I told him that the child would need to return home to allow us to discuss this with our legal department, as well as upper management, to formulate a plan on how to best serve Evelyn and her needs. He explained his distaste for the idea of her returning home, said that he is afraid of her, he's not able to sleep, etc. And then he agreed for her to return home. The investigators spoke with juvenile probation. And then I believe that the child was not removed by the department until the 25th. I think that's a fair assessment. She was actually taken into the conservatorship on the 25th. Is that correct?
That's correct.
All right. So I think at the hearing, I'm not sure if you've had a chance to review the record. Of course, Ms. Moore was present there, and I hope y'all have had a chance to discuss. I was extremely concerned with why the child was not taken into emergency conservatorship on the 24th when the father clearly was attempting to wrapper the child at the scene. My recollection is that Mr. Baronet testified that his supervisor was not available and he had contact with Ms. Davis, who indicated to him that the department could not take emergency possession of the child in a wrapper situation without a court order authorizing that. That was confusing to me. It appeared to me that the father clearly wanted to wrapper the child. He had been assaulted. We can go back through the affidavit in more detail, but that he was told that the department would not take custody of the child. And obviously I read from his statement, he said he was going to have to speak with upper management about to formulate a plan. So apparently the department says we're getting an 11-year-old girl. We're not going to have a placement for her on February 24th. We need to talk about it and we'll get back with you tomorrow. I mean, obviously that's a concern to me. I do not believe it's correct information that the department cannot take custody of a child in a wrapper situation without a court order, but maybe somebody can show me where that is not correct.
That's accurate.
So
Sorry, I didn't hear your statement, Mr. Wicker.
The judge's assessment is correct. There's no policy or procedure that says that we cannot take possession of a child, whether it's a wrapper or other child, if they're unsafe.
okay. So Ms. Surratt, I don't know if you or Ms. Moore taking lead in the hearing. It's a big concern to me. I expressed my concern yesterday in the court with the issues that I think we've been having with investigations in our area. And frankly, I will tell you that it is frustrating to me that I set a special hearing and requested Ms. Davis to be present at the hearing, and we show up for a hearing and she's not present. I understand there's personal circumstances surrounding that issue, but my understanding yesterday was that it was not an emergency situation, but just general personal circumstances. So, Ms. Surratt, do you want to make an announcement? Do you want to elicit testimony? Do we want to have a discussion? What are we going to do?
I guess, Judge, we could just have a discussion to try to answer your questions regarding the reasons that we did not take the child into care that particular evening. I wasn't at the adversary hearing, so I'm not really 100% sure what all happened at the adversary hearing and what the testimony was there. I'm assuming you don't want to rehash the adversary hearing. It's just your questions regarding that reasoning from the evening.
Sure. So, I mean, that I would be happy to just ask Ms. Davis to tell us why the child wasn't taken into the emergency custody and possession of the department on that day, February 24th. And she can tell me that, and she can speak on her own behalf, but I certainly want you to guide her through her testimony if you feel that that's important. So, Ms. Davis, do you want to tell us what happened that night and why Evelyn wasn't taken into care that night?
Yes, sir, I certainly can. On that night, Colton did staff with me. I was the program director that was on call. My recollection of that night and the information that was provided was that law enforcement was contacted after Evelyn assaulted her father. Law enforcement was on scene, but was not going to detain Evelyn. We had mental health officers also on scene who had assessed her and deemed her to not be a danger to herself or anyone else. I know that Mr. Estep expressed some concern about what he might do should she attempt to attack him again, and he was concerned that he might harm her in defending himself. However, he had an alternate plan in place that had worked on previous occasions. And he was willing to enact that plan again that night, putting both of them in their rooms, not engaging in contact. And he was willing to have Evelyn come into the home while we made a referral to the Yes Waiver program and worked with him to.
What are you basing your testimony on that he was willing to do that?
Just information provided by Colton, the investigator that was in the field.
So when he says in his affidavit, I told him that the child would need to return home to allow us to discuss this with our legal department, how is that the father expressing to him that he had a plan in place? I mean, we have a person who's dead and can't come testify. Testimony from the hearing that we had is going to reflect that Colton told him, I don't have the authority to take this child into care. She has to go home with you.
Yes, sir.
That's different than what you're telling me that he had a plan in place. So I think there's a conflict in what you're reporting that Colton said versus what he testified to. Have you discussed this with him?
Not that specific incident. I was unaware what the actual concern was for the court, so I did not have time to speak with Colton specifically about the miscommunication or misunderstanding.
You want to recess so you and he can get your story straight, or are you just gonna tell us what happened? I mean, he clearly came to court and said, Miss Davis told me I could not take the child into care without a court order and a wrapper circumstance. Now, that's my recollection. I don't know if we can have the court reporter read it back. It would probably take her a while for us to get that. So he said it. Ms. Moore can make an announcement if I'm mischaracterizing the evidence, as well as Ms. Corbin. He stated that that's what he was told. Did you tell him that or not?
That we can't pick up children without a court order?
In a wrapper?
No, I would not have told him that.
Okay. All right. Let me switch for a second then. Ms. Corbin, you were present. Maybe I'm mischaracterizing the testimony. I think we went through it a couple of times. It was very clear to me that Mr. Barnett was testified that's what he was directly told. Do you want to announce what your recollection was and maybe remind me of other evidence that was presented at the hearing that might be beneficial for us to discuss, Ms. Corbin?
Sure, Judge. No, I remember it the same way that you do, because this was obviously a big concern, and you specifically asked Colton, the dad wasn't willing to take her. He didn't think it was safe for Evelyn to be back in the home. And, why didn't you take her? And he said, my supervisor wouldn't allow me to, and then said because he was told he had to have a court order in a wrapper situation.
So I think we also had the juvenile probation supervisor present. I know that Colton or law enforcement had reached out to her. We have an 11-year-old female with significant mental health concerns. I think the department was trying to punt to juvenile detention. I think we can all clearly say that an 11-year-old girl with significant mental health concerns does not need to be in juvenile detention under these circumstances, especially with the fact that law enforcement, as Ms. Davis announced, was not going to file charges. So I think what probably needs to happen, Ms. Surratt, is you've got a problem going on. I think, Mr. Wicker, you need to do some sort of internal investigation. I think Ms. Trull indicated that Colton told her, we are not going to take the child. Upper management will not take the child. You're going to need to take her. When Ms. Trull indicated we were not going to place her in juvenile detention, he sat down and as he said in his affidavit, I told the father, we're not taking the child. You have to take her back. That is not the father having a plan in place. It's the father being told by CPS that he has to take this child back. You see on the bottom of that page, Mr. Barnett says, I spoke with the chief juvenile probation officer, Ms. Truel. I was informed that through the interaction with the father, he refused to call the child by name and continued to refer to her as that girl. He had disassociated himself with the child and no longer wanted to be responsible for her care. Let me recess momentarily from the record. I need to take a All right, so I apologize for that. We're back on the record here. We'll be back on the record. Mr. Wicker, Ms. Surratt, somebody is not telling us the truth. And it appears. I think you need to do some sort of internal investigation. We have a father, your investigator has information that he has disassociated himself from the child after she had assaulted him. He's in significant physical and medical distress. He's not calling the child by her name. He's been assaulted by her, and your investigator is forcing him to take the child back into his custody. As I said in the hearing yesterday and at the adversary hearing, I'm thankful that neither one of them was injured. Something went wrong here. Now, Ms. Davis is blaming everything on the investigator. And in the hearing, you can get a record from the court reporter to see what he testified to, and you can read his affidavit. I'm not going to assess which one of them I feel like is telling the truth or not unless we have a full hearing to determine that. On the edge of things, stepping back a degree, we are having significant issues with investigations in our county. Anecdotally, I'm hearing that there is frustration with online staff having interaction with Ms. Davis. For whatever reason, she did not appear in my hearing yesterday. You've got a problem, and it may be Ms. Davis, it may be Mr. Barnett, it may be the whole dang system, but you're going to have to resolve the problem. I don't want to have to bring you and her and Ms. Maldonado from El Paso to court. We're your easternmost county almost, and it's a long way out to Midland, Odessa. It's a heck of a lot further to El Paso. It's the way the system's set up. But we're a small little district, but I expect the full force of the state to assist us. It's a miracle that nothing happened here. And this is not going to happen again. Okay. I don't have the authority to step in and order you to do something unless I have a pleading before me. I did indicate to juvenile probation that I really didn't have any other option. Something has happened, and I want to hear from you, Mr. Wicker, what your process is going to be to resolve the issue.
Yes, Judge, and I would agree 100% with your assessment that there's some conflicting testimony regarding what was actually said and not said. The first step that I'm going to take is meet with Miss Davis and Mr. Barnett separately to try and figure out what was said by who. Are we putting things in our affidavit based on an assumption or a statement, or were you actually told these things? And then at that point, we'll have to feather out and figure out where to fix the shortcomings. But the assessment that we can't pick up without a court order in certain situations is completely fictitious. That's not part of our policy now, nor has it ever been. I can, I can say on behalf of Miss Davis, that's not a discussion we've ever had or an issue that we've ever had before. So it would be a shock to me if that was actually what Colton was told. So I need to figure out if Miss Davis's direction to Mr. Barnett was not clear, or if his interpretation of what his guidance was somehow faulty when he authored the affidavit. I can tell you that when we're staffing on call like this, that when we give a permission to removal, typically the affidavits don't come back through the program director for proofing. They're written and sent up through legal by the supervisor. So that may be something that we need to start doing, is proofing these to make sure that they're 100% accurate.
Well, your attorney signed off on it.
Correct.
So I understand what you're saying. I appreciate that. I want to ask Ms. Corbin, and then I'm going to ask Ms. Gaiman, because they were both present. And I think, first of all, you need to get a record from the court reporter as to the testimony that was taken at the hearing, because it was crystal clear to me that his indication was Ms. Davis said, we're not going to take this child, go figure something out. Okay. Ms. Corbin, do you want to give a general assessment of what your interpretation of the testimony was, and if there was some sort of misunderstanding on Mr. Barnett's part?
It did not seem that there was a misunderstanding as far as what his direction was. The indication I got from him was that he felt like he should have been able to remove the child, but was told from upper management that he could not. And that was also the indication that we received from Ms. Truel, the juvenile probation officer, was that basically they wanted juvenile probation to take over.
Ms. Gaiman, you've worked within the system and with investigators. I guess you said yesterday, maybe you've been in your role around 20 years with CASA. The elephant in the room is that there is just a general issue with investigations in our region. Will you speak to that so Mr. Richter will understand what the concerns are and your assessment of the testimony as well as Ms. Corbin's?
Well, as far as the testimony goes, I agree with what Valera, how she remembers it as well. It was very clear with Ms. Truel there and Mr. Barnett that he was told he could not remove because they didn't have anywhere to go with her that night, and see if he would keep her one more night until they could figure out what to do with her, was my understanding. As far as just a general overview, I get reports consistently that when people are making reports into the department for certain abuse and neglect situations, they're being lied to. The calls are not being handled properly. And these are by professionals, school teachers, school staff. I myself has made a report passed in just the past few months, which I will say that was handled and I did get a letter back, but I consistently get negative comments about why nothing is being done when they know these kids are in danger and being abused and no removals are taking place.
And with regards to internal staffing issues, do you want to speak to that, Ms. Gaiman?
Internal staffing in regards,
just
I guess
within the unit, the investigation unit?
Oh, well, I mean, it's my understanding, and excuse my language, is just a hot mess. I mean, there's just, there's a fault, there's a fall through. Some things are not getting through like they should.
So thank you. I guess we lost Ms. Gaiman. I guess that was her final word. Ms. Wright, let me say one thing, and then I think we're going to wrap things up and I'll kick things over to you. I've got a call actually at 11:30. I'm glad Ms. Gaiman reminded me that there was testimony from Mr. Barnett that there is no placement. The child will have to go into CWAP, so we're not going to take her. So if I remember correctly, he testified as to that on the record. If he is saying that, I don't know where that information is coming from, except that it had to come from Ms. Davis. I think personally there's frustration between investigators, the unit supervisor, and the PD, I think that there is a general frustration that they are not getting the support that they need from Ms. Davis. So I think that can wrap things up, Mr. Rapp, unless you want to make an announcement or ask a question.
I just had a quick question from some of the stuff that Ms. Gaiman was saying. Is that coming from statewide intake when these professionals are calling, or is that local investigations?
So the question, Ms. Gaiman, is the frustration that you're hearing from professionals from a statewide intake or a local unit?
A local unit.
Thank you.
I think that there are questions with regards to the professionalism of investigators. And it appears to me from a step away that there is frustration between our unit in San Angelo and the interaction that they're having with their PD. And, you know, Mr. Ricker, y'all are a long ways away from San Angelo, and you're a heck of a long way away from Mason, McCullough, and Kimball County. So anything else, Mr. Ratt, you wanted to say?
No, Your Honor.
Ms. Moore?
I would just like to ask if we could follow up for a moment with Ms. Davis about what she does recall telling Mr. Baronet, whether or not she believes that there was an interpretation issue, or just what she believes might have been the reason for this.
Okay, my suggestion, thank you, Ms. Moore. My suggestion is, Ms. Davis is under oath. I think that you need to have an internal discussion as to that. I don't want to put her in the position of testifying as to something that is not 100% accurate at this point. I think you need to do that internally. Ms. Moore, that's my suggestion, but you're welcome to ask those questions if you want.
No, I'll withdraw that, Your Honor.
Anything else, Ms. Corbin, from you?
Nothing further from me, Your Honor.
All right. Mr. Ratt, you want to wrap things up then?
Yeah, is there anything you want us to follow up with, Judge?
Well, I don't know what, I think it would be nice if we had some report with the court that said this issue has been resolved. It's beyond the scope of the hearing and the circumstances here. Look, I think being a CPS investigator has got to be one of the hardest jobs in the entire world. And I'm sure that as things go up, it's tough. We know the circumstances that the agency is in. It is a tough job. I know the pressure to keep kids out of CWAP. But this was a terrible mistake that thankfully did not end up in something horrible happening. I hope that the RD will hear what our concerns are for Mr. Wicker, and I hope that it will be thoroughly investigated. I mean, I trust that it's going to be. I hope we'll have some sort of report back in writing, Judge, this issue has been resolved. That's what my hope would be. So with all that said, thank you for being here with us today. And we'll go ahead and recess. Of course, we know we have another hearing in this case on June 18th. Thanks everyone for your time. Goodbye.
Thank you, Judge.
Thank you.